Motions, remedies, and we're on section 6. And we also have Rule 12 to talk about today in addition to our cases. We don't have that many cases, but I think they're interesting for the week. But let's first, I want to look at Rule 12. I want you to look at Rule 12 a little more carefully because it's a rule we use a lot in the Rules of Civil Procedure. And it has some ramifications to it that you should be aware of from a practicing standpoint as well. But Rule 12 is used by the defendant in response to the complaint, and it is dealing with motions to dismiss and the like. And if you look at Rule 12, it talks about a few different motions, but the one that's used most often is it's used by way of filing a motion to dismiss. And what happens under Rule 12 is that there are various reasons for moving to dismiss and the like. And if you look at the various reasons, usually they deal with procedural or substantive deficiencies within the complaint and the like. And so whether it's lack of personal jurisdiction or lack of subject matter, if you look at the different bases here, maybe the parties who should be there are not there, or perhaps legally or factually your claim is insufficient. So Rule 12, in essence, I call it a test. First about testing motions, because it allows you to test the sufficiency of the complaint to see if there are procedural or substantive deficiencies within that complaint such that the case should not proceed. And a lot of times we will use it simply to try and eliminate some of the counts of the complaint, recognizing that there are others that are more likely to be sufficiently meritorious or sufficiently pled that they could withstand a motion to dismiss. But the filing of a motion to dismiss from a practice standpoint tolls the time for us having to file an answer at all. So sometimes we will file a motion to dismiss certainly if it's grounded under Rule 11, but it also provides a vehicle for giving us additional time to respond to that complaint, because we don't need to respond to the complaint then until 10 days after a ruling on that motion. So the fact is it can provide you additional time as well by procedurally filing a motion to dismiss to test the complaint. Still obviously has to be grounded under Rule 11. If you're going to move to dismiss for one of the various reasons listed under Rule 12, as a general matter, all of those motions should be consolidated in a single one. So if you think there's a question about lack of subject matter jurisdiction and lack of personal jurisdiction and insufficiency of service of process, those motions need to be consolidated at one time and allow the court to act on it at that point collectively. There's a couple of other motions that are less utilized under Rule 12, but still there that you should be aware of. And under C, it talks about motion for judgment on the pleadings. And so then after the pleadings are closed, and the pleadings really are the complaint and the answer, then a party could also move for judgment on the pleadings. In essence, that based on the complaint and the answer, there is nothing else that the court needs to look at. The plaintiff or the defendant should recover as a matter of law, and that allows the court to then grant a motion for judgment on the pleadings. Under provision D, and this is important to recognize, if you're moving to dismiss for failure to state a cause of action upon which relief can be granted, and the court looks to matters outside the face of the complaint, like affidavits, which is not uncommon, then that might change the motion to dismiss to a motion for summary judgment. Because in a motion to dismiss, we're really supposed to solely be looking at least for failure to state a cause of action, the face of the complaint, not trying to determine whether it's true or not, but simply if on the face of that complaint does it state a cause of action under the law. If it does, then it should withstand it. But sometimes defendants will move for a motion to dismiss or in the alternative for summary judgment right out of the box. and support that motion with affidavits and the like, and that could change the motion to dismiss into one of a motion for summary judgment under provision D here, if you look at it. So you want to be careful with respect to that. You want to be careful if you're the defendant filing those motions, because if you do and you support it, it's a motion to dismiss with failure to state a cause of action. You support it with affidavits, you might be converting that motion into one of summary judgment if the court looks at matters outside the face of the complaint. Motion for a more definite statement, also contained within Rule 12, and this is provision E. And what that actually says, and I have seen this rarely used, and even on the few times I think I've seen it, it's even less often successful to, in essence, file a motion for a more definite statement. You're arguing that the complaint is so vague that I can't be expected to reasonably respond. Well, frankly, if the complaint is that sufficiently vague, then you should be moving forward to a motion to dismiss because the complaint hasn't validly stated a cause of action. And I'd rather have the whole case dismissed than just simply give them an opportunity to amend it. And so you don't see it that often. I don't think if I were defending, I would use it because I would be more inclined to move to dismiss. But I guess you could argue, you could bring a motion to dismiss under Rule 12 or in the alternative for a more definite statement under 12E. And arguably that at least theoretically makes more sense to me. But oftentimes the pleading standard is so low with respect to what is necessary under both Mass and federal rules. Simply state your facts in a clear and concise fashion. It's called what we call notice pleading as a general matter, that the standard to survive a motion to dismiss is pretty low because it's not supposed to be allowed unless it appears beyond all doubt that the plaintiff can prove no set of facts that entitle them to relief. I've seen 12E used very rarely in my 30 years, and I would be reluctant if I were you to do it, because if you even look at the language here, it's so vague or ambiguous that the party cannot reasonably prepare a response. To me, then they probably haven't stated a cause of action. I'm more inclined to move on to dismiss under 12. I'd rather be done with them than give them another opportunity to fix it. And I have seen actually Rule 12F used on occasion. It's an interesting rule where it talks about the court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. And the court can do that. The court can do that on its own as well. So sometimes there are allegations in there that you don't want to stand and you think are only provided for embarrassment or some other reason. And so you also have the ability to strike matters within a pleading if it falls within one of those reasons. I'm just trying to think if there's anything else that to talk about before this. Sometimes some of these answers, some of these grounds to dismiss, instead of being filed as a motion to dismiss, will be pled as an affirmative defense as part of your answer. And so that's another way potentially to argue some of these issues, is to simply file your answer with the affirmative defenses, lack of subject matter jurisdiction, lack of personal, and use it as part of affirmative defenses such that later down the road you may provide the further basis for that, but it's not necessary to do it at the outset. But more often you see these asserted as the very first response, and sometimes it's simply as a means of trying to whittle down some of the plaintiff's claims and the like, and they're probably their less sufficient counts as a means of potentially reducing the scope of discovery and the like, because you don't necessarily want to have to defend counts that you don't think are properly stated. And the more opportunity we have to limit the plaintiff's avenues like that, the better the course is. And so even if we start with 6 counts and we can whittle it down to 4 or 3 after the motion to dismiss, that can make a big difference at trial. What evidence is going to be relevant? Well, A, it can make a big difference at trials during discovery as to what they're entitled to get. And then B, at trial, it's going to limit the information they can admit because it may not be relevant to the counts that are remaining in the complaint. You guys have any questions on motions to dismiss? Yeah, go ahead.
If I remember correctly, some of these are use or lose, like the first time?
They're almost all use or lose.
Okay.
Subject matter jurisdiction can be raised by anyone at any time, but they're almost all use or lose.
So don't wait till if you do a first, if you do any kind of answer to the court, the first answer has to be use or lose.
Correct. If you're going to do them by way of the answer, they must be listed in your answer as affirmative defenses in your first responsive move.
So if it's pre-answer, you got to use it then. Like pre-trial or pre-answer motions. That's when you have to.
Say that again.
So if it's pre-answer or pre-trial, you have to use them then. You can't, if you don't.
Raise or waive. Let me just be clearer. If you looked at B here, how to present defenses, and I can't, my book is too small for me to get all the little subheadings down to there, but it's on the second page of my little book before, and it says how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. Responsive pleading is an answer. Okay, motion to dismiss is not considered a responsive pleading. But a party may assert the following defenses by motion. So you can do it by way of your answer as affirmative defenses, or with these enumerated defenses, you can actually do that by way of a motion instead of filing an answer. And you don't have to file an answer till that motion is resolved, and even then you get 10 days after a ruling on that motion. Okay? You know, a lot of times there may be questions about lack of personal jurisdiction or service of process. You know, you got it, but you may want for matters pertaining to time and to be able to satisfy your own Rule 11 due diligence, you may want to get some time to gather the information and the like, and so you may start out by way of filing a motion to dismiss. And you know, when we sit here in law school, it's pretty easy to say, well, that's what the complaint looks like. You know, a lot of complaints, when you look at them, you say, well, I don't quite know whether those facts are going to give rise to a 1983 action or give rise to a Claim for Americans with Disability Act. And so you may simply test the complaint to say, Your Honor, I don't think that they've got enough here to establish it. And what it also does is has the ability to buy you additional time. Questions? That's Rule 12. You see Rule 12 a lot in practice. The other two testing motions, as you know from our discussions, are motion for summary judgment, which again, you see a lot in practice. And then the last one is a motion for judgment as a matter of law under Rule 50. That's a trial device that tests the sufficiency of the evidence. Motions for summary judgment have become incredibly involved in both federal and state court now. It used to be a pretty perfunctory process where you would file it just to get a feel for the judge, and maybe you win and maybe you lose. There's an awful lot of preparation that goes into it now, required under the rules if you want to move for summary judgment. And if you don't do it right, obviously they're going to dump your motion and they don't care about you. Let's talk a little bit about Frank's GMC Truck Center, unless you guys have other questions on motions to dismiss. You know, again, the whole process, remember, is a relatively tight process. We talk about 21 days after service of the summons, and that's something I can't stress enough to you guys as new lawyers. 21 days is nothing. It comes and goes fast, And when you're juggling a bunch of things, you've got to have systems in place to make sure that those files are adequately tracked so that you do what you're supposed to do when you're supposed to do it. Because right now, you know your schedule of classes is Tuesday, Thursday, and you better be here probably in all likelihood then. But when you're juggling a caseload that most people expect lawyers to be juggling in civil litigation, there's a lot of deadlines, and you don't want to be missing any of them because you're not going to be cut much slack when you do.
If you waive service of process, can you get a 60-day? Is that a...
No, we can, but listen, we can agree if you're going to waive service of process, we can agree that you'll file your answer by X. That really is between the two of us. The problem's going to be, though, in waiving service of process, so what happens if you don't? So, okay, now I don't have your answer. I gave you 3 weeks, or I gave you a month, or I gave you 2 months. I gave you 3 months to file your answer. Now I don't have your answer. I don't have the return of service of process. I don't have the accepted summons. I can't move to default you. Now I've got to serve you. And that's always been my problem with accepting service of process is I have to have faith you'll do what you're supposed to do. Because, not to be overly cynical, but a defendant's goal is to delay. That's the job, right? Because they know every day they delay, the money stays in their pocket and it's a loss for your client. And so you hope that the attorney doesn't get too caught up in that and that, you know, okay, I'll accept service, but then I call you in 3 weeks and I don't have the summons back and I don't have an answer. What's going on? Oh, you know, am I going to hear a tale of woe that the client says no now? So now I've been shaped already. This is the way this is going to go. And again, I don't mean to sound overly cynical or jaundiced about it, but the fact is, from a plaintiff's standpoint, I was taught early on, my job is the exact opposite of the defendant's. My job is to put blinders on and head to the finish line as quickly as I can get there, because in almost all cases, from a plaintiff's standpoint, that's when the action is likely to occur, the closer we get to trial. And because now, one way or the other, this case is coming to a head. And, you know, people are a lot more serious when they have something significant to lose imminently. And so our two goals are the exact opposite, and that's the problem with allowing someone to accept service. And listen, if you and I had discussions and we had the case, we're in a good place, and you said, Mike, you know, my client will accept service of the summons, send it over to me, say, okay, Gary, when are you going to file an answer by? You said 30 days. I'm going to go along with that. I'd much rather do that. But it's going to put us in very bad footing if in 30 days I don't have that answer. Right. But frankly, I've been there before. That's just the nature of it. It's better to know sooner or later that you're a lying bastard who I can't trust your word. But that's the way it's going to be, right? You know, the very first thing you did, you lied to me, or, you know, of course you have a reason why it wasn't a lie and it's not true, but you told me something that just didn't work out. And so now you bought yourself at least, in likelihood, another 30 days because I got to serve you and you got 21 days from there. Okay, so this is the way it's going to be. It's just, so if you agree as defendants in accepting the summons, then accept it, return it, get together, get your answer together, and get moving.
I thought was it Rule 4?
4.
Yeah, I thought there was something in there that said 60 days if
I think what it says is that you have to make service within 60 days.
If the defendant waived.
Hmm?
I thought it was if the defendant says, yeah, waiver of service D, 4D. I thought it was a rule.
I think it's closer to, you have limitations. Usually it's 4 months on serving from the time the case is filed.
There is that 4D3.
What's it say?
It says time after waiver, and it says 60 days after the request was sent, or until 90 days after it was sent. So.
Okay, but that's a request for waiver. That's not an agreement to waive, right?
So I thought this was the defendant waiving his service, saying, I don't need service, I want another 60 days, and the court said I can have it. So I thought it was like a reward or a carrot to the defendant to give him more time to prepare by waiving service. That's the impression I was under when I read it.
Yeah, I don't think I've got the new rule 4D in here.
I thought it was incentive for the defendant to waive service so he could get some more time. Instead of some time to answer after waiver, a defendant who before being served with process timely returns a waiver need not serve an answer to the complaint until 60 days. So it gives you more time. If you're a defendant, I would use this. I would waive service unless you, like you say, you could negotiate with the other side.
Yeah, but no, that's, hold on.
Because it gives you more time. That's the way I'm reading it.
Yeah, I don't have, this is an older rule book, so I do not have the new rule book with respect to defendant, okay, no.
Mine's old too, mine's 2000.
Timely returns the waiver, no, you're right, until 60 days after the request was sent, or until 90 days after it was sent outside the judicial district. That's if not, I mean, it will work the same way in essence. That's if I send you a request for waiver. That's the way this provision would work. We could work the same way if we agree that you waive summons, but I've got to have the return of service from you. And you're right, what this is trying to do is avoid, the expense is relatively minimal, but what it's trying to do is at least start the process off so that the parties aren't contentious right from the beginning. But it's 60 days from the time the request was sent within the United States, or 90 outside. So I mean, the fact is that at the end of the day, that still will likely be less than 60, because you would have had you got to get the summons, and you got to talk to your client and make sure there's an agreement on it. But it does provide you some additional time to file your responsive pleading, and that's, Gary's got it under E, not 3, but again, I'm not sure what the other subheadings parts here are.
D isn't dog. It starts at D3.
It looks like mine, it's G3.
Yeah, mine's old, that's 2009. So that's why I'm looking at the new one.
It doesn't matter. With the waiver provision, you have longer to file your response, assuming that you've agreed to accept waiver of the summons. But the fact is, in many cases, it is not a burden to get someone served. It's just a relatively modest expense in the cost with respect to the other costs of litigation. $50 to $100 is relatively modest, but it does save you some aggravation if the parties are in agreement that that's the way it can proceed. Let's talk about Frank's GMC Truck Center versus GMC. This starts out with, it says, following removal from state court, the United States District Court for the District of New Jersey preliminarily enjoined truck manufacturer from failing to supply retailer with parts for heavy-duty trucks and failing to honor warranty claims. What is this removal from state court of New Jersey to federal court, and what allows something to be removed from state court to federal court? How does that work? So plaintiff files an action in state court and all of a sudden it ends up in federal court? How's that operate?
Diversity.
Say what?
Diversity, or if it's over $75,000.
Diversity and it's over 75,000, or what? What's that mean, by the way? Diversity and it's over 75,000.
No parties from the same state.
Nobody's from the same state? That's what it means?
The plaintiff is not from the same state as the defendant.
No plaintiff is from the same state as any defendant,
and there is
a reasonable likelihood
I was getting this.
of damages in excess of $75,000. That's a diversity claim. What else? Is it?
Removal jurisdiction.
That's right. That's what we're talking about, Patrick. Removal jurisdiction. What other cases can be removed from state court to federal court? So you got diversity,
Yeah, so it's,
Yeah.
federal question, and constitutional issue. Those are the three main ones. Sometimes you get treaties and things like that, but not that often. Can every defendant remove an action from state court to federal court? If so, when? I sue Kelly in Massachusetts for $100,000. Can she remove that from state court to federal court?
Federal court has to have the desire to hear the case.
It sounds like a good phrase, but we get a little more for me there than that.
And it must have subject matter jurisdiction.
Okay, so it must have subject. So what's it got? So how does it get that? What is the standard for removal? What's the definition of removal jurisdiction?
If the case could have otherwise been brought in federal court,
Very good, Patrick. If a case could have otherwise been brought in federal court,
it can then be removed.
the defendant can remove it from
Defendant can
state
remove
court
it
to
from
federal
state
court.
to federal,
If-
as long as they are not from that.
No, you're missing a
forum.
piece. Defendant can remove it from state court to federal court if
The controversy could have otherwise been brought in federal court.
the
and
controversy could have otherwise been brought in federal court,
and they're
and
not from that venue.
if
The damages are reasonably likely.
nope. And
Diversity jurisdiction?
oh, you got something here. Some of it's coming back. Okay, listen. Here's the deal, right? We're very close between your understanding of it. An action can be moved from state court to federal court if the action could have otherwise been brought in federal court in the first instance, unless removal is predicated on diversity jurisdiction, and then in that instance, the defendant cannot be from that forum. Okay? So if Kelly sues me in Massachusetts for $100,000 over there in Essex Superior Court. Mike's from Massachusetts. Where's Kelly from?
Alabama?
Is she? She's been here a couple of years now. She must be here.
My domicile.
So it still goes by domicile.
Yes.
And your domicile is always Sweet Tea, Georgia.
That's right, Evans, Georgia.
Okay?
But she
And,
established the minimum context.
well, that's personal jurisdiction, but her domicile is still Georgia. So she can sue me in federal court. Damages are likely to exceed $75,000, we said. Can Mike remove that action from state court in Essex Superior to federal court? Kenny? It's a Georgia Peach driver's license. Actually has a peach on the license. I'm going to get me some sweet tea in a couple of weeks.
That's right. Just come to my house.
Stand it, Eric. You just want a bottle of water at some point. You know?
That is our water.
No.
That's what's in the
I
Powerade
do like
bottle.
peach tea, though. I've got to give
You like that?
Yeah, I do like that.
You got to stop by the house.
Okay, but come on, back to the point. Can Mike remove that case from state court to federal court?
No.
Why? Correct.
Was
Why?
it something that
Because
the
it's
federal?
predicated on diversity.
And
He is from that forum.
he's from that forum, okay? So even though you do have diversity jurisdiction, if the defendant's is from that forum, you don't have removal. If Mike sues Kelly for $100,000 in Essex Superior Court, may Kelly remove that case based on diversity to federal court?
Yes.
Yes, why?
Because I'm not from
Because
Massachusetts.
she's not from Massachusetts, okay? If it's based on a federal question or a constitutional issue, either of us can remove. Makes no difference where our domicile is. But if it's based on diversity, the person removing it, the defendant, cannot be from that forum. Okay? Questions on that? So Frank sued GMC. He sued them in New Jersey Superior Court. Why do you think Frank wanted it in New Jersey Superior Court?
He's from New Jersey.
Oh,
He's from New Jersey and,
Easier form.
yeah,
well, better for him, right?
yeah.
If anyone has an advantage, you would think it's the local citizen who employs people in New Jersey, and hopefully, in New Jersey, he might get a favorable treatment for his claim, and that's what he was hoping for. GM wanted it in federal court. GM is not from New Jersey, so GM decided to remove it to federal court where they thought they could do better. And so off to federal court we went. And by the way, you should know that when you're admitted to Massachusetts State Court, you are admitted, you don't pass the bar, you're admitted. You then still have to be admitted to federal court. Just a matter of filing forms when you're first admitted and the like, but you got to do it. Because if your case gets removed to federal court, you're not admitted to the bar there, you're not practicing law on that case. And so it's just another set of paperwork you've got to take care of. But make sure you do, because you could say, well, I don't ever want to practice in federal court. We don't necessarily control where the cases end up. We only control what we want to do with respect to the case. So the district court granted a preliminary injunction in favor of Franks, compelling GM to continue to supply heavy-duty truck parts and to process warranty claims on heavy-duty trucks filed by Franks. GM, as a business decision, had ceased supplying the trucks and related parts and warranty service because it decided to withdraw from the heavy-duty truck market. This court, the appeals court, now examines it because they're concerned about whether the 5-part test has been satisfied, but also with respect to the district court failing to require Frank to post the bond mandated by Rule 65. So what's this bond? Rule 65 controls injunctions. What's the bond? Well, we talked about this a little bit the last time. What's the bond?
Like a security.
It's like a security?
It's money, I don't know how to describe it.
Huh?
They have to give a security.
It's like an insurance policy in case found out that the injunction should have been granted.
Right, but if you guys look at Rule 65C, it in fact it refers to it as security. The court may issue a preliminary injunction or a TRO only if the movement gives security in an amount the court considers proper to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. Because the U.S. doesn't have to issue a bond when it's a party at all. But for everyone else, Rule 65C says that they do have to issue security of some sort, which we usually refer to as the bond, to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. That could be a lot of money, couldn't it? Judge? All right, judge is going to decide based on the arguments you present. So if you're representing GM, I assume you've got a pretty good argument as to why you need a very high bond. Is that, like, why? Why, if you're GM, do you need a big bond here?
In this case, there'd be a tough argument. They'd have to prove that they were up against some potentially substantial damages against GM. I don't see that here.
Well, but how will GM suffer if this injunction is granted?
Lost sales.
Huh?
Lost sales.
Well, is it lost sales?
They wouldn't lose any sales. They wouldn't lose anything. They would continue to do business with Franks. It just might delay a contract with Volvo.
Wait a minute though. Hadn't they already entered into a contract with Volvo, right?
Yes.
Well, it was an acquisition, actually. So when they're minority in the acquisition, so Volvo has all the cards now.
Okay, so Volvo was now going to do whatever warranty service there was, parts.
There might be a dealer down the street that they prefer over Frank's, and that's probably what's happening, I'm guessing. It doesn't say that.
Well, but doesn't it, I mean, if GM has to to continue to supply parts and warranty administration for heavy-duty trucks to Frank's, pending the outcome of the litigation, I mean, it's just Frank. But when you say that doesn't sound like a lot, that sounds like if I've decided to discontinue that business, that sounds like you're putting me to some perhaps significant expense simply to service Ash when I've decided as a business decision, I don't want to do this anymore. It's not profitable for me to do it. It wasn't profitable or whatever. It wasn't in my interest to do it when I had 1,000 distributors, and now I got to keep doing it. For one, it sounds like my costs have just gone up significantly, no?
Yeah, you're warranting a service that you don't want to warranty anymore.
And it,
That's,
go ahead.
That's saying about warranties, that's just supplying parts, just supplying heavy-duty truck parts to Frank's.
But to
Yes.
supply heavy-duty truck parts, I've got to get them somewhere or manufacture them.
Yeah, which you're already doing.
Where does it say that?
You've already been supplying parts to Frank's.
Oh, I've done it in the past.
You continue to, now you decide you want to stop it.
I say I don't want to do this. Not just to Frank's. I don't want to do this business anymore.
Well, potentially, yeah, so if that's what he's doing here, but still, it's not like you're starting up something, you've already been doing it. Now, maybe, let's say it's unprofitable, and that's why, you know, Volvo bought you, and Volvo wants to spin off that somewhere other way, because it's unprofitable, like you're saying. It's still something you're already doing, you've been doing, you just stopped doing. So, the damages aren't gonna be substantial, I don't think.
I don't see. I'm not sure how you guys can decide that. I mean, again, we'd like to see some numbers here and the like, but the fact is, you know, for whatever reason, I have decided to get out of this business. To keep me in it, that's an expense that I don't want to incur. And if I don't want to incur and I don't have to incur it, then Frank's going to have to make this right if this turns out that later down the road, the court never should have made me do this.
If that was the case, somewhere in the case it would have said that GM wants to get out of that business. It's not what it said. It said it wanted to stop selling parts to him, that dealer.
Well,
Those
I don't know.
particular
I think that's an overly restrictive reading.
Jim was getting those.
Yeah.
Volvo didn't want to
The whole
take it.
service he wanted out.
When Volvo acquired GM Heavy Duty, they went through and said, okay, which dealers do we want to keep doing the heavy duty parts to? And they went and selected dealers, and the ones that weren't in that selection got cut out. That's what happened to Frank's.
Well, but they were probably likely to be Volvo's dealers at that point, right?
Had priority because they were the priority owner. Absolutely.
Well, that's what it's, right? It says Volvo, in which GM was to be a minority participant.
Right.
So Volvo was going to manufacture and market the heavy-duty trucks. As a consequence of the joint venture, GM told Frank that it was no longer going to manufacture and supply them with heavy-duty trucks and parts.
Right, so the theory is that Volvo had a preferred dealer over here, somewhere in the same geography, covering the same region perhaps, and chose this dealer over Frank's. So to continue supplying parts to both of them would hurt the other dealer, but not GM. The two dealers are competing with each other. GM is still selling parts at a profit.
I don't know that that's true.
Yeah, I don't know it either, for
Okay,
sure. But,
right.
you know, but that's
GM has
the
made the choice to
concept.
dismantle its warranty support and sell off or transfer all its parts in inventory. That tells me
Right there.
they just don't want to do the business.
I didn't hear you.
Go ahead, speak up, Ash.
GM has made the choice to dismantle its warranty support and sell off or transfer its parts inventory.
Yeah, that doesn't tell me that somebody isn't supplying those parts, whether it shifts over to Volvo or some other department. That doesn't tell me much really. To say that, it doesn't tell me that GM's going to get damaged. I don't see the damage. Is what I'm saying.
The damage is that it would force GM to continue
GM
doing something it
continues to do
doesn't
something
want
they don't
to.
want to do.
Okay,
That's-
okay, I'll buy that. Yeah.
Well, look at footnote 7, because I think that's where we're probably at least a little bit apart here, because this is the argument for the injunction, at least in part. GM does not prevail. GM will have been damaged by the difference in the amount it will receive from Frank's as payment for the parts it must provide to Frank's and the amount it pays to obtain these parts. So they weren't going to have them otherwise. By an amount it will expend to set up and administer the warranty service program that Ash just described they are getting out of, as well as the claims it will have to pay Frank's for doing the work because Volvo GM agreed to assume responsibility for all the warranty work. Frank's is saying, you know, this is akin to the orphan who kills his parents and then complains that he's an orphan, saying this is their own making here. They're the ones that chose to dismantle the warranty support, sell off or transfer its parts inventory. But, you know, GM, either way, this is going to cost GM money. The question is it a lot of money, a little money? But at any rate, whatever it costs is what we should be talking about is the amount of the bond. Because if the injunction's wrong, then they shouldn't have had to incur this cost at all. Go ahead, Sanjay.
I had a question about the bond, and I understand how it's, I guess where I'm stuck is the movement. I know that you have to post security for costs and damages, but if it's the movement, then wouldn't it be Frank's GMC that has to provide the bond?
Yes,
Okay, they have to.
they have to provide a bond in an amount that GMC will suffer as a result of complying with the injunction.
Okay, that was my.
Right, so they want, GM want, and listen, let's be honest, at this time, GM had loads of money. They weren't worried about, needing the bond because otherwise we could go broke. They want a high bond because the likelihood of Frank's being able to get and post a high bond, it makes it an additional burden before that injunction will issue. And so it's a good argument to make. It's an argument we start to make as we oppose the injunction. It's an argument then that needs to be fleshed out further when if the injunction's going to be granted, GM wants to know that if it later is determined that this was wrong, that we're going to be able to collect from Frank's. Because right now Frank's playing with house money. It doesn't cost him anything to try and force us to do something we don't want to do. But this notion of a bond can deter litigants from going forward. And there are some cases where you have to post a bond, but injunctive relief is the most common example where you see it.
Now, if Frank wins, he gets his money back.
Yeah, the bond it doesn't go to GM immediately. It's the security that is posted with the court. And really what it's designed to do is ensure that if on appeal or it's later determined that the injunction, it was wrong to grant it, that the party against whom the injunction was granted has some means of getting compensation for its damages.
Do you have to come up with the whole bond, or is there any insurance companies that post it?
It depends. There's a bonding company, I'm sure I assume they're still in business in Mass, down in Boston, called A.A. Doherty Surety Bonds. So there are bonding companies that will provide the bond, but the problem is you often need assets sufficient to cover the bond because they're only doing it as a service because they get paid. But they're going to want to know if suppose they need $1 million bond here. Well, we need to know that if Ash wants $1 million bond, Ash is Frank, that you've got $1 million in property that I can take in the event I pay out. So what happens is I'll post the bond. You're going to pay a premium to me for posting the bond. It might be as much as 10% of the bond. So you're going to pay me $100,000 to post $1 million bond. But you're also agreeing that if I end up having to pay this $1 million, that I can come after you for your assets that will satisfy the $1 million that I'm out. So for the bonding company, it's sort of like bail bonds and the like, is that they're posting it temporarily with the expectation that if they lose, they're coming after you hard to get their money back. And sometimes, if you think about it, if the bond is too high, you can go try and get it, and they can say, we're not going to give you a bond for this. We don't like your chances of winning or losing if they want to make that assessment, but B, you don't have $500,000 in assets that we can seize. Why would we take that risk based on what we're looking at? And so sometimes you cannot get the bond, even though you have a good case, because simply the bond is set at such a high premium, at such a high cost, you're not able to offer the sureties to the court in a sufficient amount. And so that's another argument. Your Honor, can we post cash alternative? Or can we post the real estate? Or can we provide some other form of security to the court that will be sufficient? Sometimes they'll say, well, talk to the council and see what you folks can agree on. Oftentimes it's not much we're going to be able to agree on. It would be nice if we could. But if we can't, then it's still back in the court's hands to try and figure out what to do. The bond becomes, in some cases, a significant obstacle to the granting of the injunction. And if you're opposing it, that's good. If you want to get it, that happens to be obviously detrimental to your request. And I could see where GM could fashion mathematically such an amount here that Frank's could have some trouble at posting the bond.
But that's sort of, this is where my problem is with this whole footnote 7, because wouldn't GM have to show? Because here it says, here the court is deciding that GM would suffer whether it stopped it, reconstituted, or whether it just continued. In other words, if it was, if
What's
it never-
good, okay, but just slow down on, let's say that. We have to agree that it's gonna cost GM money to continue in this business,
even if it just continued in the business, that's where.
right?
But
Well, it
then-
has to. No? That's cost me something.
Well, no, because you're selling something for a profit. You're assuming you're just continuing to sell stuff at a profit.
No, okay, but before we look at the bottom line, we have to agree, it's gonna cost me something.
So assuming that it does, even if they continue.
Well, no,
But there'd be
you're
a
assuming
different
it does.
price,
It
though,
has to,
right?
Robbie.
But there'd be a different price between the three though, right? And wouldn't GM have to show?
Wait, so,
So if GM was to show, see here, the court's not even requiring GM to show any damages, like how much they were anyways, because they never said they had to get a bond.
okay, but hold on, that's the first problem with the case, right?
Yeah.
How much was the bond?
They didn't.
So there was no bond, right? So that's the first problem is, we don't have to get it that much into the amount of the bond because we know it was error for there to be zero bond. Okay, so then I take my next step, and the next step for me is, and I thought we would have free, easy agreement on it. Don't we agree that it's got to, as a matter of cost, not profit, but as a matter of cost, it has got to cost GM something to continue into a business that they would have had zero cost on otherwise.
Yes.
Right, Gary?
But that's why the lower court didn't offer the bond, because they were assuming that they continued, it wouldn't cost them anything. That's what I'm thinking.
Okay, but you're using cost as net cost, and I'm just saying, at first blush, there's got to be an added cost, because over the course of the next year, it was going to, our expense in this area was zero. Okay? So there's something more than I wanted to do. Now, if Gary's point is right, that it's going to cost something, but you're going to make a profit on it, I hear that argument, but I think if it was profitable to do it with just one person, the likelihood GM would still be in this business, because with 1,000, I must be making a lot of money. And so I think the administrative expense is likely to consume whatever profit we might make with just Frank, and likely to, in my opinion, far exceed it.
Yeah, you wouldn't make, I agree, you wouldn't make a profit with just one if they're doing it. If your business is set up to do it with hundreds, they're
Right.
not gonna make a profit off of one.
And you can't keep them, they can't keep them in business with all these people.
Right.
And that's when we get to the next stage. Okay, so what's the cost of it? We never get to that. Less what is the income they're gonna generate from it? Well, then that should be the amount of the bond, right? That's one relatively easy way to work it. But we don't even get to that because the court never, it's not, was the bond of sufficient amount? There was no hearing really dedicated to what that bond should have been and what the likely costs they're going to incur here are. There's language here on this page where footnote 7 is, where it says, we have held previously that absent circumstances where there is no risk of monetary loss to the defendant, the failure of a district court to require a successful applicant to post a bond constitutes reversible error. So if there's any chance that they're going to lose money, then you got to look at the posting of the bond requirement, because in the Third Circuit at least, that rule is clear. No injunction with no bond. You get a bond, you get an injunction. And so we've got a relatively crystal clear rule here coming from the Third Circuit with respect to that bond. We're going to see some variation about that, but what we know is GM gets something, even though the amount we're not quite clear of. The court also, by the way, on the merits, right, said we don't see an immediate and irreparable injury here. If Frank's doesn't do this, how has Frank been damaged?
Lose a significant portion of his business if he can't supply parts, right?
Business, and what's that mean?
Future sales.
Sales, money. We can compensate it, GM can compensate it in money, right? You don't have really an immediate and irreparable injury. You don't have a contract that guarantees you to do this forever. GM no longer wants to do it. Whatever your losses are money. So there's a remedy at law, and that you can be compensated in that way. They're talking about here grant of injunctive relief is an extraordinary remedy. And absent the immediate irreparable injury, we're looking for, Frank is really looking for money damages here. Yes, this is probably a horrible blow to his business, but that's money, and it's compensable by money. And you can't make GM do this without that bond, and so Frank's is out. As much as our sympathies might lie with Frank and not GM, simply because it's making a business decision that it sees as it's in its best interest. Questions on the case? The bond becomes a real issue at times, and you need to start to think about it as part of an additional argument related to the balance of harms. Because if we can fashion an argument for a sizable bond, the whole case may go away. Or at least certainly any request for injunctive relief might go away simply because the plaintiff might be unable to post such a bond.
So do you always have to post a bond every time you request an injunction?
This is the Third Circuit. We're going to see a little bit of a variation because often, as we go forward, you'll see in a couple other cases here, the rule says you do. As we're going to see in some cases, not to take all the suspense out of it, but just as we're going to see in some of the cases, we're going to find that the amount of the bond is discretionary, okay? And then what we're going to find is that in some courts say, well, if it's so discretionary as to amounts, we can dispense with it completely. And that seems like then the exception has swallowed the rule. But we'll take a look at it as we come forward with a few other cases. The rule, as I read to you, talks about, it doesn't talk about it may, it talks about a requirement of the bond. Let's talk about Aoud and Mobil Oil Corporation. And this is a First Circuit case. And Gary was mentioning that it's Judge Selya's decision from the First Circuit here, who used to be the presiding judge in the Court of Appeals. And when you do read his decisions, you need to read it with a dictionary, and not even a legal dictionary, just a plain old dictionary, because he always wrote like this, and could be very difficult as well. Not just to understand, to appear before. He was tough. But I also want to mention something to you, and I'll use Judge Selya to illustrate it. In the federal court, there are also, in addition to our rules like this, and virtually in every federal court, there are also what we call local rules. And I had a great civil procedure teacher, but when I got sworn into federal court, I didn't know, she had never told us, that there were local rules of court as well, in addition to these to comply with. So I want to make sure that you're not the same boat as I was. I still answered yes when he asked, do you know that there are local rules? I figured that if he's asking it that way, there must be. But at any rate, the local rules oftentimes are things even related to housekeeping and the like. Like for instance, and this is why I'm going to use Judge Selya, one of the local rules in the First Circuit for a long time was that when you filed your appellate brief for the Court of Appeals, you also had to file a CD along with it with the contents of the brief. And the reason for that is Judge Selya was losing his sight. And so he would need to put it into the computer and enlarge the print to a size sufficient that he could read it. And the reason I'm telling you that is so that you recognize that these local rules can vary depending on where you're sitting, depending on the needs of the court, depending on the custom and practice of that court. For instance, in the First Circuit, we have local rules that say before you file any motion on any discovery matter, you must actually meet and confer with the other side. And within the motion, there must be specific references to the date, the time, the place of the meeting, who was present, what was said, what was resolved. So I need you to recognize that these local rules control the process and maybe even control your ability to file the motions and the memos you'd like. They also usually deal with the size of the font, as you probably are familiar with from your writing courses, the size of margins, how many pages can be in the brief. You don't practice law in a court without knowing what the local rules are, because if you do, you are likely to have your papers returned to you without any further comment, and the time frame for doing something might have been lost. So recognize, and the same thing applies when we're in state court. For instance, Massachusetts Superior Court has its own rules for how things are done. Probate and Family Court does as well. You always want to look not just at the main rule book, but recognize that there may be local rules or rules that are for use only within that court that additionally have to be complied with. And your non-compliance likely means you're going to lose. It also makes you look like a rube. That if you're filing things that don't comply with what the local custom is or the local practice, then you're not likely to get very far in that court. And I think recognizing what they are and what the requirements are is just good lawyering. I've said it many times in the context of both civ pro and evidence, you wouldn't play poker, or if you would be a moron if you play poker without knowing what the rules are, because you're just going to lose your money. You shouldn't be in litigation if you don't know what the rules are that control the game in the same manner. So you've got to know what those local rules are, and recognize that they're sometimes they're relatively extensive. Sometimes they don't even make sense. You know, I remember one time I had to file something in California, and this was a while back now, but I wonder if it's any different. They still use blue backing on pleadings, which from around here we abandoned that decades ago. And they also want all pleadings to be on numbered paper, you know, 1 through 25 in the left-hand margin. It seemed ridiculous at the time, but that was their rules. I don't know whether they still do. For all intents and purposes, they do. I also know that the local rules in Massachusetts, federal court, virtually everything is filed electronically. Virtually everything. So don't even bother to file a paper copy of something. And you need to not only file electronically, obviously. To do so, you must know how to do it. There's a training module. If you wanted to look at it, you could do it. It's U.S. District Court in Mass. I think it's ECF, electronic something filing, court filing probably. Yeah, ECF. And it's relatively quick to learn how to do it. But that's how you do it. It's almost all electronic in Massachusetts.
Have you had,
Probably in many other federal courts, by the way. Yep.
have you had anything returned to you for non-compliance with the local rules?
Yeah, I'm sure at one point I probably did. I can't think of it. Probably that California case, frankly. You know, probably because it might have been the blue backing, because we abandoned blue backing here sometime in the 70s. I was still in college and working at a law firm when we stopped doing that. And this was this was late 80s, it was 90s. And California was still using blue backing on pleadings. And 8.5 by 14 paper, which most people stopped doing that a long time ago. So I'm sure it was a California case where stuff was returned. And then you said, oh, geez. And then you looked, and it was even from around here. I had to create the separately lined paper, because we hadn't used numbered paper in ages. So it just, there at times it will happen. And sometimes, by the way, you've got what you expect, what you believe in the latest local rules, and there are further changes that are posted in the courthouse that you're not made aware of. I think, again, for you guys, the likelihood of that happening is relatively low now because of all the information that's available by way of the web. But if you don't have skills in that area, you've got to acquire them, because especially for the purposes of the federal courts, it is rapidly going online. Our state courts are still relatively slow in that regard, but a lot of the rules and the like are pretty easily able to be found. Pleadings is still, we use a very traditional filing basis, but the federal courts are moving away from paper completely. And I just got a notice the other day. I meant to make a note of it. I'll make a note next week. February 28th, I think it is. It's the second day of the bar exam. The federal court is having, at least in Boston, and then the others that are other days, they're having training seminar for lawyers who want to use the electronic resources within the federal court to know, system requirements, what you can use, how to use it, what you would need in order to tap into their system. And again, that's something these days that you have to have knowledge of, simply because that's the way we try cases. It's been a while since the federal court has had, at least many judges in the federal court have what we call paperless trials. All the exhibits go on a disk. If you want to call something up, it's called up electronically. If you want to put something up on the screen, it's put up electronically. Federal courts are far more electronic friendly than our state courts. Still, at the end of the day, oftentimes if you want something to be there, you've got to make sure it's there. But let's talk a little bit about this Aoud case, and we'll talk again about it because we're not going to finish it. Breyer, by the way, who you know was a Supreme Court judge, and helped to build the federal court system here on Anthony's land. Judge Selye, who was the presiding judge here for many times, and Judge Caffrey actually was from Lawrence here, and by all accounts, a real brick in the legal profession. Tough judge to appear before. So this is a tough panel to begin with, and I don't think Salim did himself any favors here. And so I want to focus a little bit at first on this footnote 2, because you read the case, and I think it's an interesting case. I don't know what you think about Mobile saying that this guy shouldn't be allowed to run another franchise, but I want to focus a little bit on what his lawyer did here. And it says, and it is well written, obviously. Aoud kept control of the station and sort of hid those actions from Mobile. And then what he did is he sues Mobile, you did on his behalf, I guess, attaching to the complaint what purported to be a copy of the Aoud-Monahan purchase agreement after discovery proved that the agreement was a fake. Footnote true. Mobile notified Monahan that because of his complicity in the fraud, it was terminating the franchise. So I read this footnote 2 on page 2. It says, in his discussion with Schultz, plaintiff inflated the price paid Monahan, presumably to give him better leverage in dealing with Mobile. The next day, at Aoud's instigation, he and Monahan prepared an ersatz agreement inserting a price of $175K, backdated and signed it. Aoud now admits that the document was bogus, and you attached it to your complaint. Now, when I read that footnote, I didn't have to read the rest of the case to find out what was going to happen to our buddy Aoud, right?
Yeah.
So, how do you avoid this being you? Right? Because you don't look the right. His lawyer doesn't look very honest here either, right?
Rule 11.
Okay, but what's that mean? What's that mean?
Can't
Because
accept things at face value. You have to just check into everything, and this guy's on this line.
Ask a lot of questions.
Yes.
oh, but don't you think with this guy I could have asked a bunch of questions and I'm going to get answers that? Because I'll bet he's a little slick. By the way, his nephew one time sat around this table when we did this case, and he said, "Hey, that's my uncle." I swear. It was. I'm not kidding. So he was reading it, and we all got a kick out of it.
I know now that owns a mobile station, I'm like thinking.
Oh, it's probably it, right? It doesn't sound that common to me.
But this one was in Lynn.
No, this was. I thought it was.
This was in Shrewsbury.
This was in Shrewsbury.
Right. The one I know was in
The one
Lynn.
you know is in Lynn.
I was just curious.
Well, maybe they
Might have moved.
maybe they removed the
Relocation.
restriction. Maybe they decided he did a good job after all. Okay, but so I really listen. You have a client. He's got some cash. Got a lot of cash.
Yeah.
Enough cash that he can buy a couple of gas stations. Comes in to see you. He's got a deal. I mean, I actually felt bad for him a little bit. No, I did. I'm running a good gas station. I want to run more. I want to make more money for both of us. Why? That sounds like a silly deal. If I can run one really good station, why can't I run 2 or more?
Oh, well and good, but you shouldn't lie.
Okay,
He wasn't trying to.
fair enough, huh?
He was trying to run the other business in disguise with the other guy's name.
Well, because I had to.
Yeah, it's a
I
white.
had to because they wouldn't let me otherwise.
It was a
So
white
back
lie.
on.
Sketchy.
I think he wanted a little more of the American dream, no? Doesn't it sound like a silly rule for mobile to say, I'm running a really good gas station now, I'm making us both a lot of money, but because we have some stupid policy, you can only run one.
But he could have sought the
That
approval
doesn't seem fair.
before he.
I thought he sought the approval, and I thought he thought, well, at least he told you,
But he didn't.
but he didn't. But how did you didn't know that? When you filed the complaint, Sandy, you didn't know that. He said, I had conversations with them, and they approved it. Right? That's what he told you.
Right?
And he gave you the contract. You attach it to the complaint. I'm just wondering how to avoid, and because I could see him coming in, and I do feel a little bad. I don't bleed for Mobile Exxon. Do you? But I can't think of a circumstance where I feel bad for those bastards. If I'm going to feel bad for anyone, I'm going to feel bad for him. No?
Well, you know, the other.
What'd you pay for gas today, Sandy? Huh?
Or something.
Yeah, getting close to $4
Yeah,
now.
it went up 11
In what?
cents last night.
A week it's gone up, a month it's gone up $0.50, it seems.
That's
Yeah.
Obama's fault.
Last,
Oh, yeah, I've read your posts, everything's Obama's fault, right? Not the greedy bastard oil companies.
Thank you.
$49 in New York right now, so.
How much?
$49.
Yeah, I know, we were in DC one time and we were complaining here, and we get there and it's like
$5.
$5.
we were like, quit complaining.
Okay, so wait a minute though, I like,
Me too.
what do you do? Are we supposed to distrust every client that walks in the door? Yeah, Sunshine's nodding her head,
I
yes.
would
We
say
talked to all the parties. that-
But who are all the parties? Monahan?
Monahan and
Monahan,
Ayubi.
mobile.
Monahan? Yeah, but Mobile's gonna tell you what? Gonna tell you no. He's not gonna get another station. He's lying about getting approval from anyone. Go to hell, he's not getting a station. So when you talk to Mobile, that's the way the defense are gonna deny everything.
But mobile's gonna tell you their policy that you can't have 2, so then you go back to your
Well-
client.
Well, you
and say
can also
liar.
ask, oh, I'm sorry.
Go ahead, no, go ahead.
You can also ask, why is that policy in place? Wouldn't you want to make more money? And if he's making you good money in that corner, he could make you good money in the other corner.
Okay, so we talked about it and I said, go screw yourself.
It's because he.
Right? Now but do you want to help him or are you just gonna say, I can't do anything for you? He's got cash, right? He's got cash. In my view, he's got a sympathetic case.
Well, I'll do
Let's
What
go.
the hell?
Let's
He's
go
got-
incorporate
he's got
himself to
paperwork
Sunoco.
Paperwork that looks like we got a shot, huh?
Let's go buy him a Sunoco.
Right. I agree.
Oh, yeah.
Yes,
So you're gonna give him business advice to buy a different station.
sure.
Or you could,
Competition.
see,
I know Mobile. Oh, that's
Right,
right.
that's it. You
think
better
that's
make
something
sure.
You think that's gonna be better?
Oh, yeah.
Okay, so now you're right. Yeah, it's gotta be within the agreement that you can't run a competing station. I think he's right. That's worse.
But why can't you try
Right?
to change mobile's policy or something, but not,
Oh, come on. What's the chance of that?
what's the
it's,
chance?
it's not the policy though. It says right here, it's mobile routinely, it says ordinarily frowned upon. Didn't say it was hard. See, the problem here is that he lied to his rep. And that's where I think the problem is.
Well, wait a minute. I need to focus. We can get into this on Thursday. I need to focus on, he lied to you too.
He did.
And he brought you right into this.
Yes.
You look like a cheat.
So don't feel bad.
I don't feel bad for him.
Well, it wasn't me. I didn't file the suit. You did. No, right? But
I wouldn't have filed.
okay, but you did.
Because I would've
And
filed
you
it
attached the
anyway.
document to the complaint that now is fraudulent, and you look like
I
a
didn't
cheat
do a good rule 11.
and a lowlife. Okay, but so what does that mean? So client gives me documents, informs me of information.
So you have to check out the documents. So you have to have a check.
So you call Monahan, he says, yeah, that's our P&S. So now what?
Affidavit.
Right. Why
Have
not?
them,
Have
verify
them
names
sign
and sign it.
Listen, honey, I don't know who the hell you are. I'm not giving you anything. No, really, right? I'm Monahan. What the hell? I'm not giving you a squat.
Well, if you're not gonna give me anything, then go to hell.
That's what I just told you. No, right? I'm not your client. Ayuda's your client.
I would have him sign an affidavit.
Who signed that? Are
My
you?
client, yeah, saying that all the facts that are citing are true.
So is that gonna do it for you? So now he gives you
Nope.
an affidavit? I'm gonna lie and cheat and phony documents.
You're gonna keep the same lie.
Just write up whatever you want. I'll sign whatever you want.
They're gonna keep the same
You
lie.
have to check the documents he gives you.
How do you do that? That's what I'm wondering. How?
Well,
How?
if he's gonna give me a contract that supposedly that Mobile says is legit, won't Mobile tell me it's not? Why would they tell me it's not? Like if I call
Well,
the
but so I'm
Mobile,
gonna play all my cards to Mobile before I really come into court? So I gotta clear my evidence with you because my guess is then I'm not gonna have to be so successful. I like playing some of my cards close to the vest.
You check it as best you can.
What's
so
that mean, though? I need
so
to know
that
what
you-
that means from your standpoint
So
as a
that you
practical
can,
matter.
in good faith, go forward and do it.
I'm with you completely. I understand the law school answer. Now I need to know what that means. I'm going to check it as best I can. Don't you think his district court lawyers will say the same thing? But now, district court lawyer, and it's not this Dave Berman because Dave only does appeals. So I don't know who the hell it is, but someone looks bad. Go ahead. You got an answer?
So, well, under the Rule 11, it's like that you've made formed it after an inquiry reasonable under the circumstances. And then it lists some other, underneath that.
Because by the way, you not only filed a complaint, you then went wild, right? You went and tried to get immediate injunctions, and all hell broke loose. All based on your fraudulent documents that you submitted to the court. I want you to think between now and Thursday, because I'm not sure what the answer is myself, and I'll think too. What do we do? Because some clients we don't necessarily trust. And they're the ones that are kind of easier because your antenna goes up, but they're still your client, right? So,
Well, I was talking to the attorney that I work with on Friday about this. How can you tell when your client's gonna be honest? And she said the same thing you do. Oh, you don't even know. You know what I mean? She just, nobody had an answer for me. I talked to 3 associates and none of them really gave me an answer that I liked.
so what does that mean we're supposed to do? And this is what I just need you to think about. Does that mean, honest to God, does that mean we have to be cynical and view every person that comes in the door with this jaundice and say, I bet they're out to screw me? I mean, because that doesn't form a very trusting relationship between us.
You give everyone the benefit of the doubt.
Oh, everyone gets the benefit of the doubt. I'm getting walked all over, all right? Listen, I didn't mean to cut you off, but I don't know. And I'm really not trying to be
Lots of
overly
reasons.
cynical.
Can't take everything.
I'd hire
But
you,
you still
Ash.
do your job and conduct a intensive investigation of.
So then tell me what else you think that he could have done here, or is this listen, you can do everything and some of them still gonna blow up. Because he's giving me a document that looks like a P&S. He tells me it's the P&S. Maybe I'll go the extra yard. Monahan says it's the P&S. What the hell else am I supposed to do? By the way, either way, I look like I was complicit in it when it blows up. And I don't want to go back to that court even for a different client because they're going to remember I was involved in this one. So does that mean we have to be careful who we associate with, who we take on as clients? Listen, I'll tell you this, I'll leave you to think about this. I've had young lawyers come in here and say, I'm going to work for X. And I say, no, I really think that's a bad idea. No, I have.
Tell me.
I have, but I really think that's a bad idea. Did you research this at all? Do you know who he is? This has been a he in the past, or she is. No, not as many she's, frankly, who he is. There's a she, a couple she's too. But, so I need to know what you're going to do next time, and then we'll talk next time about it. Oh, boy. I'm just trying to keep that law license.
Aren't you supposed to
Racking
tell
my
us?
brain for the answer. What he says.
Listen,
I don't know.
I wish I knew. Because,
I know.
especially like this. Look who's on the other side. And by the way, of course, it's mobile. They're represented by Mintz Levin. When the wolves come, they're coming hard. Okay? Because that's what they do.
What's going on at Patrick's house? How's everything going?
Take that